Usually when we talk about a multi-million-dollar corporate contract, there's this expectation of just absolute airtight precision.
Right.
Like
Yeah.
you picture these elite lawyers in a glass boardroom engineering this document where, I mean, every single comma is intentional, right? You sign on the dotted line, the terms are locked in a vault, and if anything ever goes wrong, the company just points to the paper and says, well, there it is. That's the deal you agreed to.
It feels binary. I mean,
Mm.
we really like our financial agreements to be visible, categorized, and, most importantly, predictable.
Mm-hmm.
When a company writes down that they're only going to pay you X amount if things go south, they fully expect that to be the end of the story.
But then you step into the world of executive severance here in Ontario, and suddenly that ironclad vault is just blown wide open. It turns out that meticulously crafted corporate contract might not be worth the paper it's printed on.
Not at all.
So, welcome to today's deep dive. We are looking at a huge stack of sources today. Legal briefings, case law, doctrinal analyses detailing the landscape of executive severance and equity compensation in Ontario as of right now, July 2026.
It's a very messy landscape right now, honestly.
Yeah, and our mission for this deep dive is to decode this multi-million-dollar legal battlefield. Firing an executive is arguably one of the most legally chaotic and frankly expensive things a company can do, and we're going to explore exactly why that is, keeping you, the listener, well-informed without bogging you down in all that overwhelming legal jargon.
And the stakes we're talking about here are truly astronomical.
Yeah.
What we're analyzing today isn't just about a few weeks of severance pay or, arguing over some unpaid vacation days.
Right.
We are looking at a fundamental existential clash. On one side, you have these highly sophisticated, supposedly ironclad corporate contracts drawn up by these massive elite law firms. And on the other side, you have Ontario's deeply protective, almost paternalistic employment laws.
Which is quite the contrast.
Exactly. And, right behind me, you can practically imagine a high-end corporate boardroom or a vast law library, because that is the exact arena where these battles are being waged. We're talking about millions of dollars in variable compensation, stock options, bonuses, equity, all hanging in the balance. And right now, the courts are fiercely divided on who actually gets to keep that money.
Okay, let's unpack this, because we cannot possibly understand these massive severance battles without first understanding the foundational architecture of Ontario employment law. We really have to look at the baseline rules before we can see how they just completely break down once you reach the executive suite.
Yeah, the breakdown is where it gets interesting.
So help us lay the groundwork here. When an employee is let go in Ontario, what is the actual legal framework determining what they get?
So Ontario is totally unique because it doesn't just have one simple set of rules for firing someone. It actually has two legally distinct frameworks operating at the exact same time.
Oh, at the same time.
Yes, simultaneously. First, you have the Employment Standards Act, which is commonly called the ESA. You can really think of the ESA as the absolute statutory floor. It's rigid, it's mandatory, and no employment contract can legally give you less than what the ESA demands.
So basically, this is the bare minimum you're guaranteed by the government.
That's a great way to frame it. Under the ESA, you get what's called termination pay, which is based strictly on your tenure. But it caps out pretty quickly, usually just 8 weeks of pay.
Just 8 weeks.
Right. Now, if you've been at the company for, say, 5 years, and they have a payroll over $2.5 million, you also get severance pay. But again, it's a strict mathematical formula. It's very predictable.
Right, so that statutory floor seems fairly straightforward, I guess. It's just plugging numbers into a calculator based on how long you work there. But I imagine for, an executive making 7 figures, an 8-week cap isn't exactly the finish line.
Not even close. Because operating right on top of that ESA floor is the second system, which is the common law. For literally any non-unionized employee, the common law is the default position.
Okay.
The only way an employer can get out of it is if your contract is a perfectly drafted termination clause that explicitly restricts you back down to those ESA minimums. And here's the real kicker. The common law does not care about mathematical formulas. It operates on the presumption that your job is of indefinite duration.
Meaning you're just supposed to work there forever?
Essentially, yes. So if you're fired without cause, the common law says you are automatically entitled to reasonable notice.
Wait, how do they define reasonable? Because that sounds incredibly subjective.
It is entirely subjective. Yeah. It's based on a set of criteria established decades ago, known as the Bartle factors. A judge will look at your age, your length of service, the character of your employment, which just means how senior you are, and crucially, how available similar work is in the current market.
So if you're an older, highly specialized executive, your reasonable notice period is going to be massive because there just aren't that many comparable jobs out there for you to transition into.
You've hit the nail on the head.
Yeah.
Under the common law, we aren't talking about a maximum of a few weeks of pay. The unofficial upper limit for senior employees in Ontario is generally 24 to 26 months of total compensation.
Wow. 2 full years of pay. I mean, that makes sense for someone who has dedicated 2 decades to a company. But our sources highlight a massive twist here, right? Something they call the short service anomaly.
Yes, that is a huge factor.
Because logically, you'd think that if you only work somewhere for a few months, your severance should be tiny. Like if I work at a coffee shop for 3 months and get fired, I'm definitely not getting a year's salary. But for executives, the sources show courts awarding massive payouts for incredibly brief periods of employment. How does that even happen?
It's really one of the most fascinating quirks in employment law. To see it in action, look at a recent case from the sources called Humphrey v. Manny. In that situation, you had an executive who was only 32 years old.
Okay.
She was in a newly promoted senior operations role, and she was terminated after just 6 months.
6 months. So using that calculator logic from the ESA earlier, she'd barely be entitled to anything.
Right, under the ESA, her entitlements would be super minimal. But the trial court looked at the common law factors and awarded her an extraordinary 12 months of notice.
I just want to pause on that for a second. 12 months of pay for 6 months of actual work. That is staggering.
It really is, and the court was incredibly deliberate in its reasoning, too.
Hmm.
The dismissal happened under what the judge called an ethical cloud. But beyond that, the court explicitly noted the systemic difficulties young women face in securing and, keeping senior executive roles in the first place.
Oh, wow.
And it isn't just an isolated case. There was another instance, Schultz v. Go Secure, where a vice president of sales with only 10 months of tenure was awarded 10 months of notice.
So literally a 1-to-1 ratio of work to severance.
Yeah, and sometimes it's even more extreme than that.
Yeah.
Take the case of Grimaldi VCF plus D. You had a highly specialized employee, what the court sometimes calls a hidden executive, who was awarded about 5.5 months of notice after working there for less than 5 months.
That's crazy.
Yeah, the notice period actually exceeded his entire period of active employment.
Okay, I have to push back on this a bit, because if I put myself in the shoes of a business owner, this sounds profoundly unfair. So it's like convincing someone to move across the country for a relationship, dumping them a week later, and the law says you have to pay for the reputational plane ticket back home.
That's actually a pretty good way to look at it.
But wait, isn't it unfair to the employer to pay a year's salary to someone who barely learned where the coffee machine is?
I totally understand why it seems disproportionate at first glance. But you have to analyze the mechanism of why the courts do this. They heavily recognize a concept called the stigma of brief tenure.
Stigma.
Yeah, think about it. The higher you climb the corporate ladder, the longer the recruitment cycles become. We're talking months of psychometric testing, multiple rounds of interviews, board approvals. If an executive takes a new role and is suddenly fired after 4 months, it raises massive, glowing red flags for future employers.
Oh, I see. They don't just assume it was a simple poor fit.
Exactly. They wonder if the executive lied on their resume, if they lack competence, or if there was, like, a serious ethical breach.
Ah, okay. So a short tenure actually makes them less employable than if they had never taken the job at all. You haven't just fired them, you've actively damaged their resume. So the court is funding a longer transitional runway because the employer created that stigma in the first place.
That is the exact reality of it. And it goes even deeper into employer behavior, too. The common law severely penalizes bad corporate conduct through a doctrine called inducement.
Inducement, like poaching.
Exactly. Let's say a company actively poaches an executive away from a very secure long-term job. They promise them the moon, right? Equity, long-term growth, stability. If the company then fires that executive shortly after they arrive, the court views that as detrimental reliance. You convince them to leave a safe harbor, only to shipwreck them almost immediately.
So if you're an employer, you really can't just lure top talent with big promises and treat them like disposable contractors.
Absolutely not. In
Yeah.
fact, the Supreme Court of Canada, in cases like Boston and Callow, has firmly established that employers have an implied obligation of good faith and honest performance. You cannot act capriciously.
Right.
If a company secretly plans to fire an executive, but strings them along and tells them their job is safe, maybe causing them to turn down other lucrative offers, the court will hammer that employer. They will significantly extend the notice period and potentially slap them with bad faith or moral damages on top of it.
Okay, so that establishes how long the notice period is, the actual time the employer is on the hook for. But we need to move to the real meat of the issue here, which is what actually gets paid out during that 12 or 24-month runway. Because if you're an executive, your base salary is just a fraction of your overall pie. The true legal warpath leads directly to variable pay, so the bonuses and the equity.
Yes. This is exactly where the math gets terrifying for companies. The dollars get very big very fast.
Before we jump into the legal fight over it, let's make sure we're completely clear on the mechanics of variable pay. What exactly are we talking about when we say equity in this context?
Usually we are talking about restricted stock units, or RSUs. An RSU is essentially a promise from the company to give you shares of their stock, or the cash equivalent, at a future date. But there is a catch. You have to earn them over time, which is what we call vesting.
So it's a retention tool. The company basically says, hey, stay with us for 3 years and you get this massive chunk of stock.
Precisely. And under normal circumstances, if you quit or get fired before that specific vesting date, those unvested shares just simply vanish. They return to the company pool.
Okay, so how does the baseline law, the ESA, treat this?
So the ESA draws a very sharp line. If you have a formulaic bonus, say it is strictly tied to your personal sales quotas, or a metric like corporate EBITDA, which is essentially the company's baseline profitability, the ESA fiercely protects that. It classifies it as wages, meaning it absolutely must be paid out during your statutory notice period.
Okay, that makes sense.
But if a bonus is labeled discretionary, or if we were talking about unvested equity like those RSUs, the ESA says those are not wages. They have no statutory protection whatsoever.
So under the strict letter of the ESA statute, if you're fired before the RSUs vest, you lose them. End of story.
Under the statute alone, yes. But remember that dual framework we discussed earlier. The common law acts as a massive sweeping shield for the executive here. Under the common law, there is this powerful legal fiction applied during wrongful dismissal. The court basically pretends that the unlawfully terminated employee is kept completely whole during their entire reasonable notice period.
Wow.
Yeah, the law operates as if you are still waking up, putting on your suit, and coming into the office every single day until the end of that 10, 12, or 24-month notice period.
Okay, but corporations know this, right? I mean, that's why every employment contract I've ever seen has an active employment clause. It's totally boilerplate text.
Yeah.
It usually says something like, if you are not actively sitting in your chair providing services to the company on the exact date these shares vest, you get nothing. Does that not override the legal fiction?
For a long time, employers thought it did. But the Supreme Court of Canada blew that boilerplate out of the water a few years ago with a landmark case called Matthews v. Ocean Nutrition.
Oh, the Matthews Revolution.
Exactly. The Matthews ruling was a complete revolution in employment law. The court established a ruthless two-step test to determine if an employer can actually cancel your equity during a notice period.
Walk us through the test. How does it work?
Step 1 is the but-for question. But for the unlawful firing, would the equity have vested, or would the bonus have been paid during the notice period? Since the common law pretends you're still employed for those 12 or 24 months, the answer is almost always yes. And if yes, you are legally entitled to the money.
And what's step 2?
Step 2 asks, is there clear and unambiguous language in the contract that explicitly takes that specific common law right away?
And I'm guessing a generic active employment clause doesn't cut it anymore.
Not even close, because under the legal fiction of the common law, you are considered actively employed during the notice period. To survive step 2, the contract must explicitly state that your rights to the equity cease upon written notice of termination, regardless of whether that termination is lawful or unlawful.
Wow, that's specific.
It is, and it must expressly state that you waive your right to claim common law damages in lieu of the bonus. Almost no historical corporate plans were drafted with that level of extreme precision.
Wait, I really have to challenge this. Let's talk about bonuses for a second. If a contract literally slaps the word discretionary in bold letters across a bonus plan, can a judge really just ignore that? Like, completely ignore the plain English meaning of the word and force the company to pay it anyway?
What's fascinating here is how the courts see it, because this is where a lot of companies get caught off guard. The courts use what's called the integral part of compensation test. They will absolutely pierce that discretionary veil. They do not care what label HR put on the document. They care about the substantive economic reality of the relationship.
So if the company calls it discretionary, but they've paid it to you every single year without fail, it's not really discretionary.
Exactly. If you receive that bonus with historical regularity, And if it forms a substantial part of your expected annual earnings, the court says it is an integral part of your compensation. It is legally owed, regardless of the discretionary label. There's a case in the sources, actually, Adelman v. IBM, where an executive sued over a so-called discretionary bonus.
And what happened?
The court awarded him $680,000 for it.
Just staggering amounts of money. So if you are an executive listening to this and you have a standard active employment clause in your RSU or bonus agreement from a few years ago, you are likely sitting on a multi-million-dollar legal myth. The company thinks they're protected, but if they fire you, that contract is probably going to collapse in court.
That is the precise reality. And because the Matthews test destroyed all this standard corporate boilerplate, highly sophisticated employers realized they had a massive vulnerability. They had to adapt, and fast.
Which is the perfect bridge to our next topic, the great equity divide of 2025. Because if employment law makes it virtually impossible to take away unvested stock, employers came up with a clever workaround, right?
They certainly tried.
Yeah, they started hiding these RSUs in entirely separate U.S.-style commercial agreements. They tried to bypass Ontario employment law altogether by saying, hey, this stock grant isn't an employment perk, it's a separate commercial transaction. And this adaptation caused a massive judicial earthquake, literally ripping the Ontario Superior Court in two.
It really did. It created a total fracture in the legal landscape.
Mm-hmm.
We have two major decisions from 2025 that perfectly illustrate this irreconcilable conflict. Let's start with the big win for the employers, which is Wigdor v. Facebook Canada. Dr. Daniel Wigdor was the director of research science at Meta. He was terminated without cause, and at the time, he held millions of dollars in unvested RSUs.
Okay, so what happened when he sued for his reasonable notice?
The court looked at his main employment contract and found that the termination clause violated the minimums of the ESA. Because it was defective, the judge threw it out and awarded him 10 months of common law notice.
Okay, so he gets 10 months of his base salary, but what about the millions in RSUs that would have vested during those 10 months?
He lost them.
Really?
Yeah, the court decided to completely bifurcate the relationship. They ruled that the RSUs were housed in a completely standalone, distinct commercial contract. The judge determined that RSUs are not wages or benefits under the ESA, which means they do not inherently have to be continued during the statutory notice period.
Wow.
Because this commercial agreement had flawless, U.S.-style exclusionary language, the court ruled it was legally insulated from the void employment contract. The employment ship sank, but the equity ship was a totally separate vessel, and it sailed on just fine.
And there was a fascinating detail in the sources about Meta's behavior here, too. Meta had actually withheld nearly $100,000 of his undisputed mandatory ESA statutory severance pay for 10 months, trying to force him to sign a release to get the money.
Which is a clear violation of the ESA. You cannot withhold minimum statutory entitlements to force a signature. Meta tried to blame it on an administrative error.
Did the court punish them for that? I mean, that seems pretty egregious.
Surprisingly, no. The judge criticized Meta heavily, calling their excuse unreasonable, but ultimately ruled that the conduct didn't meet the extremely high legal threshold required to award punitive damages. That threshold demands behavior that is exceptionally harsh, vindictive, or malicious.
Interesting.
So the Wigdor decision became a massive blueprint for employers. Isolate your equity plans into distinct commercial contracts, and you can successfully force executives to forfeit their stock.
But the celebration for employers was incredibly short-lived, because just months later, we get a second ruling, Liggett v. Viva Software Systems. And the judge in this case completely ignores the Wigdor logic. Right?
Completely rejects it. Kevin Liggett was a senior product manager with 4.5 years of tenure. He sued, and he won 6 months of common law notice A&E, over $90,000 US for his RSUs.
Wait, how did the judge justify giving him the RSUs if they were in a separate agreement?
Well, in Liggett, the judge flatly refused the idea that equity plans could be treated as insulated commercial contracts. The court ruled that if equity forms a fundamental part of your compensation for the labor you provide, it is an employment matter. Therefore, it is entirely subject to ESA scrutiny, period.
So the Wigdor ruling treats the employment contract and the equity contract like two ships passing in the night. But the Liggett ruling treats them like a train. If the employment engine derails, the equity caboose goes down with it.
That's a perfect way to visualize it. The Viva contract had language saying that you lose your equity on your last day of actively providing services. But the judge pointed out a fatal flaw. Under the ESA, your employment legally cannot end until the minimum statutory notice period expires.
Ah, I see.
Therefore, any contract that tries to cut off your compensation before that statutory clock runs out inherently violates the mandatory ESA statutory notice period, making the forfeiture clause entirely void.
And didn't the judge also take issue with how these American-style contracts are actually written? I know they can be pretty dense.
Yes, the judge absolutely blasted the commercial agreement as convoluted and opaque. They pointed out that it required employees to literally cut and paste provisions from multiple different documents just to decipher what their basic rights were. Furthermore, granting a corporate committee unfettered discretion to just unilaterally decide when an employee stopped providing services created severe ambiguity.
And courts hate ambiguity.
Exactly. A foundational rule of contract law is that ambiguous clauses drafted by the employer are always interpreted in favor of the employee.
So we literally have two judges in the exact same court system looking at almost identical situations and coming to completely opposite conclusions. Wigdor says the commercial contract is supreme. Liggett says the paternalistic employment statute is supreme. That must leave HR departments and employment lawyers pulling their hair out.
It is total, absolute darkness. If we connect this to the bigger picture, nobody knows which interpretation will govern their specific contract if they end up in court tomorrow. It's a philosophical clash between the supremacy of commercial contract law versus the protection of provincial employment statutes.
Which brings us to the pivotal events unfolding right now in 2026 and what this actually means for anyone negotiating a severance package today. Because this irreconcilable paradox just can't last. The chaos is heading to a boiling point.
It is heading straight to the Ontario Court of Appeal. The appellate docket for 2026 features a triumvirate of cases that will decide the future of executive compensation Wigdor, Baker, and Wayfair. In Wigdor, the employee is appealing the loss of the RSUs, and the employer is cross-appealing the massive award of common law notice.
And the macroeconomic stakes here are massive, specifically around how RSUs are classified. Let's walk through the math on this for a second. If the Court of Appeal sides with the employee, basically adopting the Liggett logic, and declares that RSUs actually are wages under the ESA, what does that do to a tech or pharma company?
It triggers an existential financial crisis for them. In Ontario, the law requires employers to pay a minimum of 4% to 6% vacation pay on all wages. Normally, a company just calculates that on your base salary. But if the Court of Appeal rules that restricted stock units are legally classified as wages, their value must be factored into all statutory calculations.
So wait, if an executive vested and cashed out $2 million in stock over the last few years, the company suddenly owes them an extra 4% on that entire $2 million.
Exactly. And now multiply that retroactive recalculation by every single executive and senior engineer in the company who has received equity over the past few years. We are talking about an unmitigable, multi-million-dollar liability spike that could literally wipe out a mid-sized tech firm overnight.
No wonder the corporate world is terrified. The sources even mentioned that the Canadian Association of Counsel to Employers Case to See is officially intervening in the Wigdor appeal to fight this, right?
Yes, they are intervening.
And if the courts rule against them, the sources suggest these global companies might just abandon the Ontario court system entirely, forcing all executives into mandatory private arbitration or making their contracts governed by Delaware law instead.
It's a very real threat. The corporate defense bar is practically begging the appellate court for a return to orthodox, predictable contract interpretation. They want a system where a contract means what it says, rather than having entire compensation schemes struck down based on hypothetical technicalities, which is what the Baker and Wayfair appeals are also addressing.
So we've covered the history, the mechanics, and the looming legal showdown, but let's bring it back to practical reality. If you are an executive listening to this deep dive right now, and you are staring down a termination or trying to negotiate an exit while we wait for these 2026 appellate decisions, so what does this all mean? How do you use this chaos to your advantage today?
Well, in legal negotiations, total ambiguity equals massive leverage. The vulnerability of historical corporate drafting gives transitioning executives disproportionate power at the negotiation table today. If HR hands you a standard forfeiture clause saying you lose all your invested stock because of an active employment requirement, you can aggressively call their bluff.
How exactly do you do that?
You use the threat of the Liggett decision and the strict Matthews test. Demand to see the full 40-page underlying plan documents, the ones nobody actually reads when they click accept on a web portal. Have a lawyer dissect it. because chances are the language isn't tight enough to survive step 2 of the Matthews test.
And you don't necessarily have to go all the way to trial to win, right? You can use the sheer expense and risk of litigation to force a settlement.
Absolutely. You can use this leverage to negotiate cash in lieu of your vesting equity, demanding they pay out the value of the shares that would have vested during your notice period. Or you can demand that your vesting schedule continues uninterrupted as part of a structured settlement. The key is, you do not just have to walk away empty-handed simply because a piece of paper says so.
And for the employers listening, the imperative is equally clear. Stop relying on generic saving clauses. You can't just append a sentence at the end of a bad contract saying, this agreement complies with the ESA, and expect it to magically fix defective forfeiture language. You also need to pay absolute minimum statutory entitlements immediately upon termination. Trying to withhold them to strong-arm an executive into signing a release is practically begging for a lawsuit and moral damages.
The ground is truly shifting under everyone's feet right now. Precision in drafting is really the only protection left.
And that wraps up our deep dive for today. Thank you for acting as our guide through this incredibly complex, high-stakes terrain. I think the biggest takeaway here is crystal clear: the era of the boilerplate executive termination clause is dead and buried. You cannot just accept the first severance offer you receive, and companies can no longer rely on lazy legal drafting to protect their equity pools.
Well said.
But before we go, I want to leave you with a final provocative thought to mull over on your own. The sources we review today focus heavily on how this legal battle is being used to maximize severance payouts for departing executives. It's all about how much the individual can extract on their way out the door. But consider the long-term flip side of this equation. If the Ontario Court of Appeal ultimately rules that RSUs are wages, thereby forcing companies to pay massive retroactive vacation pay and assume these unpredictable, unmitigable liabilities, how will the market react? Will startups and multinational tech firms operating in Ontario simply decide it's too financially toxic and stop offering equity altogether? Could these highly employee-friendly rulings accidentally kill the very compensation structures that attract top-tier global talent to the province in the first place?
It's a huge question.
It's the classic pendulum swing, really. If the law protects the employee too fiercely, does it eventually destroy the ecosystem that employs them? Something to think about the next time you look at your compensation package. Keep questioning, keep learning, and remember, just because it is printed in a contract doesn't mean it is set in stone. The vault is wide open. Thanks for joining us, and we'll catch you on the next deep dive.